CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like that want it. They don't talk to me. They back. That want it. They don't talk to me. They back. That want it. They don't talk to me. They back. That want it. They don't talk to me.
Welcome back to the CLS Talks. I'm Lionel Coveney. He's Des Carty. Des, how are you?
I love the way you put that. He's Des Carty, yes.
I'm trying to at least pretend that we've some kind of real on-air experience or something like that. We're in episode 2 of our feedback special. Loads and loads of feedback coming in, and it's always great to receive. So we'll just go straight into it. This latest mail is just a quick note, lads, to say keep up the good work / great work, or stroke, whatever you want to call it. I used what I've learned from your emails last March and walked out of Trim Court with my head held high and left behind a so-called prosecuting solicitor sitting on his arse wondering what the something just happened. Regards, PC. So that's a bit of good feedback, no question in there per se, but it's good to see that somebody is using the knowledge that they have managed to procure from either here or elsewhere for positivity.
I'd love to know the details of this, to be honest with you. It seems like it was fairly straightforward, but sure, we might never know.
Yeah, it would be interesting to know though. So by all means, PC, if you want to get back in touch, do.
Police constable, yeah.
Or
politically correct.
Politically correct, yeah, my favourite. Hi there. I can't afford to go to these talks as I was made redundant in 2011. Is it okay to ask a few questions related to consent and circuit court with regard to judges' jurisdiction over me? Well, what do you think, Des?
Okay, well, we'll deal with the first part of that the man alleges he can't afford to go to the talks. Now, that's one of the reasons we put out the CLS Talks, is to relay a lot of the information that would be relayed to you in a class situation or a tutorial situation. So the other question there is, you don't really need a lot of money to be involved in what we're doing. You need to have your head switched on, listen to stuff, perhaps read what we're suggesting, do your own research. Then the second part of the question, is it okay to ask a few questions? Yes, ask a few questions.
Ask away. I mean, that's what this is all about, really. Not just the CLS Talks, but any of the work that we do. It's about asking questions.
The question he has is a broad question, so I think we'll look at it. We'll try and deal with it as we normally do. The judge's jurisdiction. So, in essence, in most cases, by just simply attending the court, you're giving over jurisdiction.
Yeah.
Now, unless you go into court and say, well, I don't consent to you having jurisdiction, I'm just here to observe what's going on, you have given over jurisdiction by attending. There's lots of ways to give over jurisdiction. A lot of people do it by lodging affidavits. That's giving over jurisdiction. The analogy would be, I always give people, is that very often I have people sitting in front of me one-to-one, and I'd say to them, do you have children? And very often they do, obviously. And then I say, well, have the children ever fought with each other?
Yeah.
And most children do fight with each other if you're in a family situation.
Not in mine, no.
Not in yours.
No, I never fought.
Same here. Obviously, that's why we're here today. We never fight.
Of course.
So, in most situations, bar yours, of course, Lionel, children do fight with each other as your siblings. And what I'd ask the parents then is, well, how do you deal with that? So the child would come and say, well, he did this and he did that and she did this and she did that. And then the parents, because the children have come to them making their arguments, would be in a position to make a decision.
Yeah.
So they're adjudging what the two parties have said, be it the two children. It's a strange analogy, I know, but this is the way the court look on you.
Yeah, sure.
If you're going to court. And in most cases, obviously, parents, irrespective of what they say, generally have favourites in certain situations or circumstances. So in this case, when you're in the court, the judge is acting like a parent and you're coming in acting like a bold child. So by making an argument to the court, by arguing with the other party, you're giving jurisdiction for the court to make a decision. And it's as simple as, or as complex as that, as you want to see it. So the judge then, by you coming in and saying, well, I didn't do this and I did do that and she did this and he did that, and you're talking about a bank, or be it I don't know, it might be the guards, it might be something else. By making that argument, you're giving evidence.
Yeah.
And so therefore you're allowing the judge to make a decision based upon what you've said. Now, this is where we come in and say, well, don't make an argument. Ask questions instead.
Yeah.
So therefore you're getting whoever is accusing you of something to put forward their evidence, which is the only basis on which the court can basically make a judgment then. You haven't given over jurisdiction for the court to make a decision about you. And you're going to then cross-examine or challenge the validity of what they've said to show them up to be liars or misleading or whatever it might be. So jurisdiction comes in many forms. It's nothing to do with geographical jurisdiction. In some cases it is, there's technical issues there, but in most cases it's just a matter of, because you're in the court, you're giving yourself over to the court for the court to decide what to do with you.
Yeah.
Based upon the principle of, well, there's two children arguing, and the judge will have a favourite, and it's usually the barrister, the plaintiff's solicitor, whatever it might be. It's not you. You're not.
So you're almost, it's like you're granting a tacit permission to rule.
Correct.
Okay.
That's it.
Right.
So that's jurisdiction in a nutshell. Now, it can get more complex, and there's an awful lot more to jurisdiction. Jurisdiction is really where everything is at. And once you fully comprehend and grasp jurisdiction, you don't give it away easily in most cases, once you grasp what the fundamentals of it are.
Good stuff. Well, the next one is a double question. So, it's not a double question, but it's a double mail. The first was, why are the High Court allowing cases to proceed when the affidavits are wrong? And it's followed up with, then, the position in relation to the above is the following. 1, the incorrect folio numbers are on the deed of appointment. 2, the instrument in relation to the same folio in the property registration upon it, there is no folio number that is not referenced at all on the DOA. 3, notwithstanding the above, the receiver instructed our tenant to pay all rent into their account. 4, any other people with a similar problem? I would be most grateful for any assistance. Kind regards, NR.
Okay, right. The first, we'll try. Probably the best way to handle this is probably to do it in reverse. Any other people with a similar problem? Well, yes, there's loads of people out there with a similar problem in relation to having a receiver in taking charge over the property and attempting to take charge over the tenant. Now, we'll be looking at the semantics of the words that are being used here. Point 3 was, notwithstanding the above, the receiver instructed our tenant. So again, you're latching or attaching yourself to the term tenant. Now, this is a discussion we had privately, Lionel, in relation to this. You see, the state can interfere or intervene, i.e. the banks can interfere and intervene, the judges, the courts can intervene, and the receivers can intervene when you have a tenant. That is going to be the problem.
Yeah.
You see, you would have a tenancy agreement. So what you're doing is, by having a tenancy agreement, you're going into the legal land and saying, right, okay, well, what I'll do is I'll have a tenancy agreement, and what I'll do is because there's a tenancy agreement, you're given the court jurisdiction and the receiver jurisdiction to decide what to do with that tenant.
Right.
Now, if you don't have a tenant, they haven't got jurisdiction. They haven't got right to approach that private party and say anything to them or insist that they do anything for them.
So it's demonstrating how important the actual language and what words specifically are used is.
If you have a private agreement, private contract, perhaps a private license in place with somebody that's living in that property, as opposed to them being identified as a tenant or a landlord, you're removing yourself from the legal aspect of it. It's a private agreement that you have. Nobody can interfere with a private agreement stroke private contract. It's that simple.
It reminds me a lot of the discussions we've had on this show about income tax and what income is and whether wages or tips versus a salary fall under the category income. So again, it comes down to the language and understanding what each word means and how you can be held liable if you use particular language.
Yeah, now again, you see, a lot of the times errors sometimes are what we would call willful errors. People make willful errors in the context of coming from the legal perspective.
Yeah.
Sometimes a willful error would be put in there, like it says here, the incorrect folio number is on the deed of appointment. So you will go in there and say, well, actually, if you were in court, most people would say, well, actually, the deed of appointment isn't valid because there's an incorrect folio number on it. Right, but then you're getting into the argument and you're recognising that the deed of appointment could be valid.
Yeah.
You see. So what's the point in arguing something in terms of recognition of the deed of appointment? It's the deed of appointment that needs to be challenged, not the error, perceivably, that the judge can have corrected.
So you're looking to roll it back as far or as early into the process as you can and work from there rather than really getting into the middle of the case, because potentially you could have tripped them up much, much earlier and then use that later on in the case if you needed to.
And again, any recognition of a deed of appointment gives cognizance and weight to the jurisdiction of the court being able to make a decision.
Right.
So my point there perhaps would be, my approach perhaps would be, if I was this man or woman, would be say, well, I'm not sure what a deed of appointment is, what it's all about, but I know that you haven't got the right in law to go in there because you do not have my permission. Mm-hmm. Now you're bringing it back to something else, you see. And a deed of appointment, I mean, quite literally, irrespective of anything else, I could hand you a deed of appointment to do something for me. Now, it doesn't necessarily have validity when you go out on the street to do something. Yeah? Does that make sense?
Yeah, complete sense. Yeah, I get that.
So, although you have my authority to do something, what you might be doing may be unlawful.
Yeah.
It's like a drug peddler. You know, he'll have his supplier. The analogy is more or less the same. So the supplier gives the peddler the authority to go out and do business for him, but it doesn't mean to say it's lawful.
Yeah, and it doesn't mean to say that the actual guy who's peddling it won't have some kind of repercussions down the line with somebody else, i.e. the police or whoever.
To lawfully do something in terms of a receiver, they have to have a power of attorney.
Yeah.
As in, you have to say to them, in law, here's my authority in law, and this is something that is provided on a separate sheet of paper under the Power of Attorney Act. Now, I don't remember the year, I think it's 1960 or something like that, but the people can look that up. So there is a specific form that has to be given to give somebody a power of attorney in law, which is not what receivers operate under. You ask for a power of attorney, they haven't got it. So they do not have the power to operate on your behalf, although they infer they're actually working for you under a deed of appointment. But that deed of appointment has no validity in law.
Interesting and powerful indeed when you actually recognise that.
Yeah, well, again, it's another thing then going into court and making the argument. So a lot of paperwork has to be done prior to that. And it sounds like this man or woman is in the middle of something that is going to be difficult to get out, because if on paper to us they've recognised that there may be a deed of appointment by saying what they said, they've stated here, the incorrect folio numbers are on the deed of appointment. So I would imagine reading that they've already accepted that the deed of appointment in itself might be valid. Which again gives jurisdiction to the court to try and say to them, well, we still recognise that the deed of appointment has validity because you've said the deed of appointment, and all you're doing is contending an error. That's all you're doing. And we can correct the error, can't we?
And by God, they will and do.
Very fast. Okay, so like it's a very, very, very complex question. We don't know the full detail of it. Now, we don't have to know the full detail of it, but it's a position whereby we've seen it before. People get entrenched in this argument about a deed of appointment being recognisable or not. You shouldn't be in that argument. You should never get into that argument. And equally, if you're giving cognizance and weight to the identity of having a tenant in place, you're back in legal land with them, giving them jurisdiction to make a decision because you've said, well, I have a tenant. And it's inferred here from what this man or woman has said that there is a tenant in place, there's probably a tenancy agreement, and they're recognising themselves as being a landlord, as opposed to a private owner who's made a private agreement with somebody to live in that home. And that's it. So
sometimes I think if you don't want to get injured in battle, don't walk onto the battlefield. Have the discussions off the battlefield with whoever your foe happens to be in a safe place.
In a critical way.
Yeah.
But again, it's not easy to get yourself to that place. But again, I keep saying, and you keep saying, Lionel, go back and keep listening to what we're putting out on air. I think it's vitally important that you reprogram. It's not a nice term to have to use for people, but I think you have to reprogram your mind to think in a different way.
Yeah.
And you won't just have that program then in your head. You'll have an experience of, well, I've been programmed in that way, now I'm programmed in this way. But you can objectively look at the way you were programmed and the way you are programmed now. So you're not really programmed, you're looking at things critically and objectively from two positions.
Yeah, that makes sense.
Okay. I'm glad something makes sense. Finally.
So the next one. If your name and your address is your property, kind of difficult to comprehend names as a property, then is anyone allowed to trespass on your property? Would this not include public servants, think tax office or any government department, police, politicians, county council personnel, etc.? Would they not be trespassing on your property? Because the state or crown, etc., copied your given name, is this why it is called your first name in the legal sense? And also copied your inherited surname, is this why it is called your second name in the legal sense? Then they continue to think they have a legal, not lawful right to trespass as they think they still own what they copied? Would it not be a good idea to simply reply to any correspondence with your instructions that no one is allowed trespass on your property? Would it not also be a good idea to include your own terms and conditions, i.e. a heavy financial penalty, for example, should any of them ever contact you again? Or of I.
Okay, well, I can't really challenge any of that, to be honest with you. Now, obviously, have your say in it, Lionel, and give us what you think. But I can't really challenge the validity of that, because the question boils down to, can you basically protect the name that you're using? And yes, you can.
Well, you can, and there are several ways you can do it. One way, potentially, for example, could be to common law trademark the name.
Yeah.
Sometimes people will throw back the argument, well, you have to have a statutory trademark and you have to apply for your trademark to the state and then they can revoke it or whatever. Well, you don't have to. You can have a common law trademark and it's lawfully valid and it recognises that your property is your property. And then you could, for example, if somebody is using your property in a way that you don't like them using it, you could issue some kind of an estoppel order or some similar notice, cease and desist, in the same way as Coca-Cola or some other brand would if you were using their trademark. And then you could issue a fee schedule potentially, and if they continue to use it, you could start charging them, and maybe you could go on the attack in that case instead of always being on the defence. So yeah, I mean, the crux of the matter is that, can you protect the name or the property? And you're right, Des, absolutely you can. I've seen it done on numerous occasions. It can be quite difficult then to follow up on, but if you're willing to do it, it can be done.
Absolutely. Look, I think the writer has answered their own question. We can't disagree with any of that. There's ways to do it. There's a trademark process in common law to follow. But it's, again, it can be as complex or simplex as you want to make it yourself.
Yeah.
A cease and desist notice very often will work anyway, irrespective of that. We do know of people that have actually been paid money for trademark infringement. So we know it can be followed on. Now, of course, you don't go charging like 100,000 euros for every time somebody has. It depends, of course. Again, if you're Coca-Cola, you probably would, or if you're McDonald's, you probably would for trademark or copyright infringement. But it's context. You know, if somebody has used your name and they shouldn't be using it, you might charge a fee schedule of maybe €5 a day for every time they attempt to use it, or it might be €10. You know, it has to be reasonable, because at the end of the day, if they're not going to pay you the money they owe you in terms of infringement, you then may have to revert to going to a court, a small claims court, or whatever. So you have to be able to present the picture that what you're seeking is reasonable. So if you're going into a court, be it the High Court, we'll say, for claiming €1 billion for trademark infringement, it's not necessary that the judge will laugh at you, but they might laugh at the extremity, and they wouldn't perceive that as being reasonable for what has been done to you. So they'd be laughing at that context of it. But if you walked into one of the lower courts or small claims courts and said, well, look, actually, they owe me €2,000 for trademark infringement. They've been sent the relevant notices. They've been asked to cease and desist. They didn't do it. We sent them a valid lawful invoice for the sum that they're required to pay for the infringement, and they haven't paid it. We've sent it 3 times. We've sent them a notice to say they must pay now, or we take them to court, a default notice, so on and so forth. We've told them we're lodging paperwork. They still haven't responded, blah, blah, blah. So you have to paint a reasonable picture. So is that when you do, or if you do decide to go to court to take them to task over it, the judge will say, well, that's reasonable. You carried out all reasonable steps to allow these people to stop, first of all, and then to provide you with the relevant trademark compensation for the infringement. And if all that looks reasonable, and you have a very valid, straightforward invoice that you've invoiced them looking for the monies that they owe you, then the likelihood is you'll win the case.
Yeah.
But reasonable is the key word here. You have to be perceived to be reasonable and present a reasonable case, and that's it. And then it doesn't get any more complex. That's the way I think. Now, it's worked in the past for people whereby they haven't actually gone to court because the amounts they were seeking were reasonable.
Yeah.
Make sense?
Absolutely. Yeah. And with that in mind, it brings us on to the next one, which is relevant. Thanks for asking for questions. I have the name trademarked and copyrighted. eFlow and their solicitors keep sending me bills which are returned along with an invoice for €1,000 for using the name. How do I go about collecting on the invoices? Is there a way, a system, or someone who will go after it? And that's from Mr. T.
Okay. Now, I don't know the full context of this. But again, I suppose the default position would be you would have to go to the court to recover this. But I would suggest perhaps that in this context, but I don't know how reasonable or unreasonable, but on the face of it, it looks like €1,000 for using the name in this case might seem unreasonable.
Yeah.
Now, I'm not saying it is. I don't know the man or woman involved. They might be in big business. They might be producing records. They might be in big production. So €1,000 to me on the face it seems unreasonable. Given I do not know, I want to qualify that I do not know the man, the woman involved. But again, you'd have to look at that and say, well, is that reasonable if you wanted to go to court to recover this cost? And perhaps that's one of the reasons why they haven't settled, because they perceive that you won't get anywhere in court with that because it's unreasonable.
And to play devil's advocate for a second, with regard to being reasonable in court, what is the position of the law? Is it not the case that the law is just the law, and regardless of the figure, the law should be applied? Where does being reasonable actually come into it with regard to a judge making his or her ruling?
Well, again, it's quite arbitrary depending on the case you're bringing. Now, obviously, there's limits to every court. So if you go into that bracket, you're very soon going to find yourself, after a while, having to consider going into the High Court because of the sum involved. Now, they would look at this in the context of, well, how were you damaged? You know, it's all about damages.
Yeah.
How specifically were you damaged by them using this name? Now, it's very reasonable to expect that they should not be using a trademarked name if you've given them the relevant notices. But the judge may say, well, what does this man make in a day, in a week, in a month? Okay, and does he use this trademark? Is this part of his makeup in terms of generating himself a wage or herself a wage? So they would look at the damage caused. Was there a damage caused by the e-flow or whoever it was writing to them? How was there a damage in that? Now, it could be damage for stress, harassment, blah, blah, blah. There's a whole plethora of things. But if you don't have quantifiable damages, you can say, if you can say to the court, I was damaged by this, because of this, and this is what happened because of it.
Sure.
You have to have grounds. Damages are grounds. So if you don't have grounds, the judge will look at that and say, well, you actually don't have grounds to bring a case here. So we're not going to give you anything. But again, if all reasonable steps were taken and say, well, actually, they did damage me because I lost this because of what they did.
Yeah.
Then, you need to be able to demonstrate to the court of that. Now, the forerunner to that is, if you're lodging an invoice with them, and they don't challenge the validity of the invoice, then after 2 or 3 invoices of the same thing, if they haven't challenged it, the validity stands. It gives it more weight.
Okay.
But equally, the court will say, well, how have you been damaged? We want to know. Have you broken an arm? Have you lost some hair? Have you suffered stress?
Yeah.
Can you quantify the damage? Now, some damages aren't quantifiable, but they will take that into consideration as well, that they realise, well, not all damages are quantifiable in terms of measuring if you've broken a thumb or a finger or whatever it might be. So they will take that into consideration, but they won't go to extremities and say, well, actually, you get €1,000,000 there now because I think that's fair.
Yeah.
You know,
yeah.
So they'll try to quantify. So you need to be able to quantify yourself how you were damaged.
Right, so it's not just a case of going in and saying, right, the law says A, B, C and D. There is actually more to it there.
The law will tell you, like, the law should be there to back up what you're saying.
Yeah.
Really.
Yeah.
That's all. But you need to be able to quantify how you have been damaged.
No, that makes sense, because otherwise anybody could go in and start charging €1,000,000 for receiving a letter, and then the courts would have to pay out on that, and that's never going to happen.
The process, it's kind of I would use the term necessarily in terms of some of the people we work with. We would have accused the courts and the plaintiff and perhaps the solicitors, the banks, whatever it might be, of an abusive process, of just bringing the stuff to court to harass, to try and get something from the defendants that they're not entitled to. An abusive process is a key term to use, but equally it can be turned upon you as well if you're not careful. If you can't quantify what it is you're seeking and why you're entitled to it, it could be levied at you as an abusive process. So the court could preclude you from going again in that context. So you have to be extremely careful if you do bring somebody to court that you have got grounds. It's all about grounds. But if you don't have quantifiable damages to some extent, you haven't got grounds to bring somebody to court.
Okay, so be reasonable about it being the key. Well, I think that'll do us for another episode. We have another feedback special on the way with the next episode next week. So thanks as always, Des, and we'll talk again very soon.
Thanks, Lyle. Speak soon.
CLS Talks.